Intellectual Property Day by National IP Awareness Mission, IP Literacy Week in collaboration with Ministry of Education's Innovation Cell, AICTE, and Ministry of Commerce and Industry Department for Promotion of Industry and Internal Trade Office of the Control General Patents, Designs, and Trademarks organized by Entrepreneurship Development Startup and Innovation Cell. Today, we all are gathered here to give a cheers to those intellectuals who has contributed for the glory of the world, to celebrate the week of World Intellectual Property Day. World Intellectual Property Day is annually 26th April. The event was established by the World Intellectual Organization in 2000 to raise awareness of how patents, copyrights, trademarks, and designs impact on daily life, and to celebrate creativity and the contribution made by creators and innovators to the development of societies across the globe. 26th of April was chosen as the date of World Intellectual Property Day because it coincides with the date on which the convention establishing the World Intellectual Property Organization entered into the force in 1970s. To endorse the intellectuals in India, the government of India has launched the Kapila scheme, that is Kalam program for IP literacy and awareness, which will create appropriate awareness regarding the need of IP filing, mechanism, and methodology involved in filing IP in India and in globally, especially among students and faculty of higher education institutions. This scheme also provides financial assistance to the institutions that are part of the higher education institutes for filing patents. On this occasion, EDSI cell of Neville Wadia Institute of Management Studies and Research has arranged guest lectures for all as always. Neville Wadia Institute of Management Studies and Research Pune has developed a mechanism for entrepreneurship development and self-employment through this cell. The EDSI cell will enable, facilitate, and support the students of the institute from ideation to startup through constant guidance and mentoring. The purpose of this policy is to promote entrepreneurship and make students explore various opportunities in the field of startups and innovation. This policy will help EDSI cell to act as a platform to motivate, guide, and help students in their entrepreneurial ventures. EDSI cell discover and create awareness of entrepreneurship as a career option among the students and to motivate students to take up entrepreneurship as a career option. EDSI cell arrange regular interactions with successful entrepreneurs to create, foster, and promote the spirit of entrepreneurship among the students by conducting workshops, guest lecture, counseling, mentoring, and orientation visits to entrepreneurial ventures. ADSI cell constantly works to develop skills for evaluating, articulating, refining, and pitching a new product or service offering, to develop relationships with various external agencies and leading financial institutes for supporting the students of the institute. One of the members of the EDSI cell, Pranjali Ghotikar from MBA1, has created a short video of EDSI cell of Neville Wadia Institute of Studies, Management Studies and Research, which will give short information about the cell. I request Pranjali to please play the video.
Yes. Sir, could you please make me host so I can share the video?
Yeah, sure, ma'am. Yeah, Pranjali, now you are the host.
Thank you.
कुछ पाने की हो आस आस को धर्मा हो जो खास खास आशाएं हर कोशिश में बार बार दरियाओं को आर पार आशाएं तूफानों को झील के मंजिलों को छीन ले आशाएं उम्मीदें हंसे अब मुश्किल नहीं कुछ भी नहीं कुछ भी आशाएं हंसे अब मुश्किल नहीं कुछ भी नहीं कुछ भी उड़ जाए लेकिन खुशी अपने संग तुझको वहाँ जन्नत से मुलाकात हो मेरी हर दुआ आशाएं गिरे उम्मीदें हंसे अब मुश्किल नहीं कुछ भी नहीं कुछ भी आशाएं
Yes, over to you, Pradyum.
Thank you so much, Pranjali, for this wonderful
Introduction दे रहे
introductory video of entrepreneurship cell. Now I request our Honorable Director, Dr. Anand Sir, to inaugurate the today's session and give us some of his insightful views on the occasion of Intellectual Property Literacy Week.
ये रिकॉर्डेड है क्या पहले से?
नहीं, वो रिकॉर्ड कर रही है अभी. मुझे बोला दे कुछ.
Anybody is having their mics on, please mute themselves. So can the sir take over?
Yeah, thank you. Good morning, all of you. On behalf of NWIMSR Institute of Management Studies and Research, I warmly welcome all the participants of this program. As an institution, we are very happy to announce that our institution has been confirmed. Is there any disturbance?
I request you everyone, please mute your mic. We are getting the lots of noises. Thank you.
Again, I welcome all of you. We are very happy to announce that our institute has been confirmed as the online center for the hosting National IP Awareness Mission Event 2022 by Education's Innovation Cell, EICT, under it is the Indian Patent Office. This program will create appropriate awareness regarding the need of IP filing mechanism, methodology involved in filing IP in India and globally, especially among the students and faculty of higher education institutions. The government has launched a campaign namely Kapila, that is a Kalam program for intellectual property literacy and awareness campaign on 15th October 2020 to increase the awareness regarding the protection and exploitation of intellectual property. Also to provide funding support in order to promote filing of the intellectual property in higher education institution. So this is a very good initiative has taken by our institution. Convener of this program, Dr. Shilpa Kankorkar Madam, who has taken the lead to organize this event and make the grand success of the institution in this innovation activities of the EICT. Once again, I welcome and congratulate all the participants and our convener to this program. And best of luck this event. Thank you very much.
Thank you so much, sir, for your words of wisdom. Now, taking over the program. Once Aristotle said humans are superior to others due to our exclusive ability to reason. The roots of human successes are entrenched in human philosophy and sciences. And Kapila's scheme motivates us to go to the path of innovation with the help of philosophy and sciences. Today, some special guests with us. Our Mrs. Manjusha Bobde ma'am. Bobde ma'am have completed their BSc in computer sciences. After that, ma'am have completed their masters through LLB and LLM in intellectual property rights. Now, ma'am are working as senior examiner of trademark and geographical indicator in Mumbai. I would like to request Bobde ma'am to take over and guide us all through the subject.
Thank you, sir. Sir, host disabled participant screen sharing. Hello.
Yes, ma'am.
Yes, Pranjali
Sir,
just
allow
make,
me.
yeah, Pranjali just make ma'am
Yes, ma'am.
host.
Yes, ma'am. Now you can share the video.
Okay. Okay. Thank you, sir. It is visible for everyone?
Yes, ma'am. Yes, it's visible.
Okay. Before starting, our today's program is IPR for startup. Okay. Before coming to the topic, first we have to know that what is IPR. Property, everyone knows that. Okay. IPR means intellectual property rights. Everyone knows about the property. That is bank, balance, gadi, bangla. All these things come under the heading of property and we can easily protect it. But due to the advancement in science and technology, new kind of property come into existence. Okay, that property is called this property is called intellectual property because it is created by human intellect using his brain. That's why it is called intellectual property. Then intellectual property covers patent, design, trademark, geographical indication, copyright, semiconductor integrated circuit, and layout design. We find different IPs in a single product. For example, if we take the example of this laptop, the laptop is an invention. Okay, it is protected under patent. Then there is a symbol of Apple, which protected under trademark. The design of laptop is protected under Design Act, and the circuit which is inside the laptop, that is protected under SICL design, that is semiconductor integrated circuit layout design. So in one product there are different IPs. Then intellectual property, as I earlier said, that the property which is made by using human brain, human labor, and the available resources. By using all these things, intellectual properties are made. Then importance and significance. What is the importance of intellectual property protection? That if we protect it, then we can exclude others from utilizing it. We can commercialize it and earn the profit from this intellectual property. Utilization and commercialization. How we can utilize it and commercialize it? We can use it for ourselves. We can license it or assign it to anybody. Then franchises, merchandise, and all this way we can earn monetary benefit. Then first we come to patent. Okay, what is patent? Patent is an exclusive monopoly right granted by government to the patentee for 20 years from the date of filing for commercial gain in consideration of full disclosure of his invention as a traditional right and not territorial right and not worldwide. What gives patent? Patent gives an exclusive right to use our invention and restrict other from using it without my permission. Okay, who granted it? It granted by the government. To whom? Who is the inventor? That is patentee. It is valid for 20 years, and by protecting this patent, we can gain commercial benefit. We can use it for commercially and acquire monetary benefit. But for that, what we have to do? We have to disclose it to the patent office. Then it is a territorial right, not worldwide. Means if we register it, we protected it in India, then it is we got the protection only for India, not the worldwide. Then did we got the protection for every invention? No. For the protection, this criteria should be fulfilled by the patentee. That is, The invention should be new. It is granted for product and process also. It should be useful. It should be novel, unique होना चाहिए. Then non-obvious, and most important thing is not public knowledge before the filing date. When we apply for protection of patent, then it is not known to anybody. Then we come to design. What is design? The design of cloth, fan. Here are some examples: bag, then portable washing machine. Okay, any design which is applicable to the article. Design, ornamental or aesthetic aspect of an article. Features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, whether in 2-dimensional or 3-dimensional or in both forms, any industrial process or means, whether manual, mechanical, or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. Design may be any kind of design, but the most important criteria is that it should be applicable to the article by way of industrial process or manual, and it should be judged solely by the eye. Where we are using this design, we can judge by the eye. It is valid for 10 years. If we applied for the protection of design, then it is valid for 10 years and it is extended for 5 years. So totally we got the protection up to 15 years. These are some examples of design. That is the design of the bottle. Then toy car, design of watch, table lamp, inhaler, bed sheet, ornaments design, design of teapot, furniture, shoes. Then we come to trademark. What is trademark? Trademark is any name, symbol, device, or combination of thereof, anything, okay, which is capable of we can see it, which is capable of geographically presented. Then a trademark is any word, name, symbol, or device, or any combination thereof. It can be anything. It should be name or symbol or device or word can be a trademark. It identifies and distinguishes the source of goods or service of one trader from those of others. Why trademark is important? Because it identifies the source, means who is the owner of that product and which services they are providing. That information gives us by trademark. For example, if we take the example of Tata, okay, from Tata we can clearly identify that that product belongs to Tata. Then function and importance. Provides exclusive monopoly over a class of goods or services. What is the use of trademark? Trademark gives us an exclusive monopoly right over a class or goods or services. For example, if we take the example of pantaloon, that if we see the pantaloon, immediately we relate it to the cloth. Okay, and if we register the pantaloon for the cloth, then nobody can register it for cloth. Then allows a business entity to build public goodwill and brand reputation, which is the most important thing, that the trademark allows business entity to build a public goodwill and reputation. Then identifies the source, origin of goods or services, that who are providing that goods and services. Assure customers about quality of goods or services. That if we consider the Tata, then we know that the product is the quality of the product is very good and their services are also very good. Then subject matter of trademark. Under trademark, what we can register? Okay, we can register slogans, tagline, slogan, then trademarks, okay, trade name, collective mark, for example, CA, CS, that the people collectively using the same mark, okay. Then certification mark, that is ISI mark, hallmark. Then tagline, for example, a dil mange more, shape mark, the shape of this Coca-Cola bottle. Then sound mark, we can register sound as a trademark. We registered the tune of Nokia as a trademark. Okay. Then how to indicate your trademark? Once your trademark is registered, then you can use this R symbol in a circle in your product name. Okay. And if you applied it and it is pending, then you can use TM. Then how to protect your trademark? The trademark registration is optional. However, registration has certain advantages. It is not compulsory to register. Okay. But if you register it, then you will get the advantages. Then registration available at a national level. As I earlier said, in respect of patent, same, the registration of trademark is also territorial. Okay. Registration is available at national level and international level. Then initially registered for 10 years can be further renewed indefinitely for again 10 years. Listing trademark rights are lost. If we did not renew it, then your trademark will lapse. The existing trademark registration is governed by the Trademark Act 1999 and the Trademark Rule 2017. For detail, there is a website we can go to and visit. Then copyright. Okay, what is copyright? Copyright is nothing but the right of making copy. Before going to that, we see what the copyright covers. That is subject matter of copyright. Under copyright, what we are protecting. We can protect literary work, artistic work. In artistic work covers painting, sculpture, architectural work, photograph, then in carving, drawing, map, all these things come under artistic work. Then dramatic work, choreography, drama, then musical work, everyone knows the musical work, then sound recording work and cinematographic film. All these things comes under Copyright Act. Then what does Copyright Act gives us? Okay, the copyright gives us a bundle of right, automatic right, exclusive right given to creator of original work of authorship. It gives us so many rights, including exclusive right given to creator of original work of authorship, allows to choose the ways his or her copyrighted works are made available to the public. He will choose to whom he will allow to make the copies and prevent unauthorized copying and reproduction. If we protect our work under copyright, then it prevents unauthorized copying and reproduction. Most important thing is copyright cannot protect an idea. Okay, it protect, it prevent unauthorized copying and reproduction. For example, if I write a book on how to make a laptop, okay, then I cannot I can't stop anybody from using that process of making copyright. Okay, by reading that book, anybody can make a patent, but no one can make the copies of that book. Then rights of authors of copyrighted work. If we copyright our work, then we got economic right and moral right. Scope of economic right. What we can do under economic right. Okay, we got reproduction right, distribution right, right to create derivative work, right to communication to the public, then right of public performance. Reproduction of right means I will decide how it will be reproduced. Okay, to whom I will give it to make the copies. Then distribution right, who will distribute and how will distribute my work. Right to create derivative work. If I want to translate my book, if we take the example of book, I am the writer of the book and I want to translate it in another language. Okay, then how will it do, who will it do it, all these rights comes to me. Then right to communication to the public. How will it communicate to the public? That rights also comes to me after copyright protection. Then right of public performance. If I write a play, director of a play, or then it depends upon me who will where the that play will perform. I'm giving you the general idea of intellectual property. Okay, that is important for you before coming to our topic. Then term of protection. That is published literary, dramatic, artistic, and musical work is valid up to life of author plus 60 years. Then cinematographic film and sound recording. It is valid for 60 years from the date of publication. Once the film is released, then from that day it is valid up to 60 years. Then broadcast reproduction right. It is valid up to 25 years from the year following the year of broadcast. If the India-Pakistan, we take the example of India-Pakistan match, okay, or any kind of match, any match. Once it is broadcasted on television on any channel, from that day, it is valid up to 25 years. Then performance right. It is valid up to 50 years from the year following the year in which performance is made. Then we come to SICLD.
I request all the participants to kindly mute your mics, please. It is disturbing the speaker. I request all the participants to kindly mute your mics. Yes, ma'am. Please continue.
Okay. That is semiconductor integrated circuit layout design. Okay. Semiconductor integrated circuit means a product having transistor and other circuitry element inseparably formed on or inside a semiconductor or insulating material designed to perform an electric circuitry function. That is, this kind of circuit comes under semiconductor integrated circuit layout design. Then layout design means a layout of transistor and other circuitry element and includes lead wire connecting such elements and expressed in a manner in SIC. The semiconductor integrated circuit layout design registry Delhi is the office where the application of layout design of integrated circuit are filed for registration of created IPR. SICLD is an important IPR for protection of product with fast changing technologies such as electronic gadget, computers, etc. It is very important because it reduces the size of our computer and TV also. Initially, there is a box size TV and computer also, but now it is a LED. Slim, flat computers and TV we are getting. That is due to semiconductor integrated layout design. The registration of layout design is for a period of 10 years from the date of application filing or first commercial exploitation, which is earlier. It is valid up to 10 years from the date of registration. Sorry, from the date of application. When you apply it for registration, from that date, it is valid up to 10 years or filing first commercial exploitation. When we use it commercially, from that day, it is valid up to 10 years. Then we come to geographical indication. Okay, what is geographical indication? A geographical indication is an indication that identifies a product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. Geographical, what identifies the geographical indication, or what we identify from geographical indication? That product comes from that specific geographical region. It possesses some qualities and reputation that are due to that origin. For example, if we take the example of Nagpur orange, okay, it got the geographical indication. The environment in Nagpur is very good for oranges. Due to that, its quality is very good. Okay. These are some examples of geographical indication, that is Darjeeling tea, then Makhana marble, Bomblivina. All these are examples of geographical indication. Geographical indication is granted to, is given to food product, textile, agriculture product, manufactured product. We can give geographical indication to all these products. That is Darjeeling tea is agriculture product, natural product. Then Makrana marble. Then Ratlami silk, food product. Kanchipuram silk, that is textile. Katputlis of Rajasthan, handicraft. Then Baga print of Madhya Pradesh, Bengal Pattachitra, Cherial painting, Bidri ware, Varli painting are some examples of geographical indication. That is natural product. Magi pan, Devanali pomelo, Appimendi mango. All these are examples of geographical indication. Then we see the validity. Which intellectual property is valid for how many years? Patent. Patent is valid for 20 years. There is nothing called global and international patent. As I earlier said that if we registered it in India, then it is you got the protection only for India. And if you want protection in other countries, then you have to protect it in that country. Then design. It is valid for 10 years plus 5 years. First, it is valid up to 10 years, then it may be extended up to 5 years. So total, we got 15 years protection. Then trademark. Indefinitely, subject to renewal, initially for 10 years. Once we got the registration, it is valid up to 10 years. After renewal, we can get protection for next 10 years. And if we do the same process, then for indefinite time, we can protect it. Geographical indication. Indefinitely subject to renewal, same as trademark. Then copyright. It is valid up to 60 years for published literary, dramatic, artistic, and musical work, lifetime of the author. We see it, okay, already. Then who can apply? Person, not individual, not for GI or legal representative person, includes firm, partnership, small entity, and a body incorporate. Who can apply for the registration of intellectual property? Any single person can apply. But in geographical indication, a single person cannot apply. For that, association of person, organization can apply for registration. Then legal representative person includes firm, partnership, firm, partnership firm, small entity, and a body incorporate also apply for registration. Then all IP rights are territorial in nature. All IP rights, patent, design, trademark, GI, copyright. Where you got the protection, it is protected only that country. If you want protection in other country, then you have to protect it in other countries. All these are IP, okay, which we have to protect. Then importance of intellectual property for startup. Why intellectual property is important for startup? The driving force behind a startup is a novel idea. Putting that idea into practice successfully is what transforms small startup into multi-billion-dollar corporations. The purpose of intellectual property law is to protect those ideas and concepts that underlying your new company, enhance your commercial value. Why intellectual property is important? Because this is an idea, okay? With the help of IP, we can gain your brand name, your reputation. This is an idea. This is the most important assets for your company, which enhance your commercial value, which gives us a brand value. The other side of the issue is an important, that is exploring IP possibilities also helps protect startup from infringement claim against them. Part of the IP process involves searching for other companies that might already have rights to certain invention or trademarks. Finding out about these companies early can save your startup from costly infringement lawsuit later. After, okay, why this is important to protect your IP? Because IP gives you an identity. It increases your brand value, which gives you an identity. Okay, that's why it is very important for a startup to protect your IP. And it is easy at the initial level. Then reason to secure IP right for your startup. That is deterring other companies from unfairly profiting off your material. Formal IP protection comes with registration, which puts the world on notice that your patent, logo, or software belongs to you. This protection can help your company avoid litigation in many cases. Other companies should first check with the United States Patent and Trademark Office to see if material like yours is already in use. Deterring other companies from unfairly profiting off your material means once you register your logo, trademark, software protected, okay, if you protected your patent, then it gives an exclusive right to use it, okay, and the protection can help your company avoid litigation in many cases. If you before protecting it you started and you got a reputation, goodwill, okay, then another company or any other person can should started using this patent. They can use similar logos for their startup or for their business, okay, and they can take advantages of your reputation, and it is loss for you. Your profit will decrease, okay. For that you have to protect your IP. Then if you come to know that the other business entity or other person are using your logos, brand name, patent, then you have to fight for that one. Means it gives protection. The protection can help your company to avoid litigation. then before filing any, if you register your patent, okay, then there is a provision before filing, we can search whether the same patent, same trademark is already registered or not. They can find it, and if they come to know that it is already registered, then they will not apply for the same. Then presumption of ownership. Once you get a goodwill and acquired a reputation, okay, then the another person will easily come to know that this belongs to that person, so we will not use it. Then protection from infringement suit. Okay, if you register your intellectual property, then it protects you from infringement suit. Then there is no need to go to court and fight for your IP property, that it belongs to you. If a startup doesn't go through the process of securing IP rights, you have no way of knowing whether what you are using already belongs to someone else. Properly acquiring IP rights protect your startup from expensive infringement litigation later when you discover that someone else already owns the right. If you initially not protecting your IP, and if anybody using the similar or same IP, then you have to go to the court, fight for that priorly you are using that and the another person is copying that, and it is very expensive process. You have to hire lawyer, pay them, then you have to pay the court fees, then your time will be also wasting in all this process. So it is better to protect it. The key ingredient to competitive advantage. Once you protect your IP, if you register your protect your patent, trademark, copyright, design, then it is helpful for you in competitive world. Then security and investor appeal. If your startup connect with a novel idea or type of software, not protecting your IP could put your entire business at risk. If you are not protecting your IP, then your entire business will be at risk because anybody can use your ideas and it is not good for you. Then consequences of not protecting of IP for your startup. Someone else can patent your invention. If before protection you use it for your business, then anybody can use it. You limit or destroy your ability to profit from your IP. If you will not register it, then anybody can use it and make a profit from that one. You put your startup at risk for costly litigation. You put your startup at risk because anyone can use your IP. Then what are the benefits of startup intellectual property protection? Okay. Which benefits are given by the government for the startup to protect intellectual property rights? The government would pay suppose professional fee for the service getting the IPR, that is intellectual property rights, to the advocates or trademark agent in charge of handling the intellectual property right process. If any startup want to register their intellectual property, then the government will pay the fee of that advocate. Okay, first it is not necessary. If you want to register your intellectual property, then it is not necessary you have to hire any advocate or agent. You can file it yourself also. But if you want any advocate, if you want to take the help of any advocate or trademark agent, then the government will help you to pay them. According to the scheme, facilitators will not levy anything from a startup. The fees are paid straight by the government. Okay, the government has provide facilitators. Apart from trademark agent and advocate, there are facilitators which helps startup, okay, to protect their IPs, and for that the government will pay to them. Then startup can get trademark, patent, design services by paying them only needed legal fees, and professional fees are excluded as a part of SIPP scheme. Government has provided a SIPP scheme, that is Startup Intellectual Property Protection Scheme. Okay, under that scheme, the government will pay the trademark and patent agent. Okay, and the startup, their professional fees are excluded. Startup will not, you did not need to pay them professional fee. You have to pay them only legal fees, that is filing fees, which the office required. Then startup can get a complete start to end array of service under the Startup Intellectual Property Protection Scheme, consisting of general advice, helping in drafting application, filing and preparing responses to examination report, appearing at constant contest opposition, hearing and ensuring the final disposal of the application of IPR, intellectual property. Like once you take the help of facilitators or trademark or a patent agent or advocate, okay, under that scheme, then they will help you from start to end, that is from filing to getting the registration certificate. They will help you. For effective execution of the scheme, the DPIIT has empaneled different facilitators who are required to provide intellectual property right related services to startup. Okay, DPIIT, that is Department Policy of Industrial Policy and Promotion. That department empaneled different facilitators. Okay, who are that facilitators? That are patent agent and trademark agent who are registered in CGPDTM. Okay, these persons are appointed to help the startup how to apply, then what are the complete process of getting the registration, and they help us at every stage. And if you want the list of the empaneled different facilitators, then you have to go DPIIT website. You will get the full list of facilitators, those who are expert in different intellectual property, that is for trademark, patent, design, and all these things. Then fee structure. Okay. Startups has to pay the same fee as the individual has to pay. For example, for trademark, there is a fee of 4,500 for individual. If you are a startup, then you have to pay 4,500 instead of paying the fee which is applicable, which has to pay the other entity, that is body incorporate company. They have to pay 9,000 rupees. But if you are startup, then you have to pay 4,500 only. Then in case of patent also, if the individual person has to pay 1,600, then startup also eligible to pay 600 only. 1,600 only. Then startup companies are allowed to file expedited examination. There is another provision. Okay, if you are a startup, then there is a provision that you can file expedited examination. What is expedited examination? There is a lots of pendency in our office. Okay, there are so many applications are coming every day, and it is examination, and the examination is done On that basis, for example, अगर हमारे ऑफिस में 1000 एप्लीकेशन एक दिन में आ रही है, तो हम जैसे जैसे एप्लीकेशंस आती है वैसे वैसे हम उसको एग्जामिनेशन करते हैं, फर्स्ट कम फर्स्ट सर्व on that basis. But if you file an expedited examination, then you come first. Okay. अगर आपका नंबर 100 है and you file the expedited examination, it is applicable for startup. Then you come first. Means the time limit is reduced. Then fee structure. Expedited examination fee for startup is 8,000. Okay, in case of patent. Whereas for other companies, 60,000 rupees. The fee structure is very less for startup. DPIIT scheme for startup, that is reimbursement of agent and expenses, as I already explained. That is various form. Okay, if you want to file a patent, trademark, design, trademark, all these things, then on that website the different forms are available which we can visit and check out. Then role of IPRs in patent system, that is encouragement for improvement of technology. Okay, it encourages for improvement of technology. Then providing disclosure in protection in the form of reward. Then making profit or earning royalty through putting the invention into practice. You can make profit or earn royalty through putting the invention into practice. Then transferring into public property after expiry of term or cessation of patent. Once the time limit of the patent is over, then it is transferred to the general public. Then suggestion, share benefit of patent system, utilize resources through organized R&D activities, capture global market judicially, earn profit through protected market. That is what benefit you will get if the startup protected your intellectual property. Then this is a contact detail for further training, or if you want any other information, detailed information regarding intellectual property, the trademark, design, patent, or anything, you will got from this Rajiv Gandhi National Institute of Intellectual Property Management, which is situated in Nagpur. This is our phone numbers. This is our website. You can go to that and inquire about that. Okay, thank you. First, we know what is intellectual property. I give you the general introduction about that. The detailed knowledge will be given by our examiner, that is Bhumika Kumari, and the facilities which the government had provided for startup. I said that. Okay, I think it is clear for everyone. I hope so.
I know, ma'am. Thank you are not the words which will actually please an intellectual, but we are really thankful for your time and presence, which filled us with productive knowledge. So anybody from audience have any questions, please feel free to ask.
Ma'am, I have one question. If I go for registration of this patent, is it a worldwide acceptable or only in India?
No, sir. It is accepted only, protected only in India.
Okay. And what about worldwide patent?
Then you have to apply in that country.
Okay. And about suppose two persons come at one by one and they don't know who has invented. At that time, what you do? Whom do you give preference to for the patent?
First come, first serve, sir.
Okay. Okay.
That's why it is very important to protect your IP before publication. before using it commercially.
Suppose by fluke, two applications with the same type of product or some patent comes for the application. In that case, what do you do?
Sir, first come, first serve, as I said. Who applied first, he got the protection.
Madam, I am a startup guy. I just want to start the e-commerce online portal. I just want to ask like what I can take IPO in terms of the concept or in terms of logic, what I can take, because e-commerce is a very common platform. So I want to start food delivery for e-commerce solutions.
First, sir, you have to protect it under trademark.
Okay, trademark in the sense logo and my mark, correct?
Your name.
My name. Okay. What anything else I can do?
Sorry?
Anything else I can take the IPR?
Sir, once you fixed your name, then you have to apply it in the trademark registry.
Okay, so only trademark registry what I can apply in the e-commerce.
You are delivering the goods now. You are in delivery services.
Yes, yes.
You have to register trademark, so that no one can use this your mark for that services.
Okay, is there anything like I can take also the patent registry for my
Sir, patent is given only for invention.
Okay, invention is the like I have a new concept, something logical concept, which is I'm going to apply in my platform. Is that can I can take a patent?
It depends
ideation.
upon which. Sorry.
I have some ideation which is very unique. Okay, so for that I want to apply for patent so that any other platform can apply for that patent.
No, sir. Patent is granted only for invention.
Okay, only for new invention.
Only for invention. And which idea you want to protect it means अगर पता है कि कौन सी आइडिया है तो उसके बाद पता चलेगा कि उसको अंडर कौन से हेडिंग हम रजिस्टर कर सकते हैं, मतलब प्रोटेक्ट कर सकते हैं. जैसे अगर डिजाइन है तो वो अंडर डिजाइन एक्ट आएगा, इन्वेंशन है पेटेंट आएगा. अगर आपका लोगो है, ट्रेडमार्क है, नाम है, कोई भी डिवाइस है तो वो हम ट्रेडमार्क के अंदर पेटेंट कर सकते हैं.
नहीं, आई एम गिविंग एग्जांपल. You understand better. So see, I have an ideation, but something in social impact, whether I want to create some marketplace, okay, whether like any home worker can get a job or come to my platform. So some of the other additional concept ideation is there, and this concept is nowhere in India anywhere. I want to create the huge job opportunities for everyone. So this is a unique concept. So can I take this kind of pattern so that tomorrow cannot copy on my similar ideation?
So you are providing the services, okay, and these services are provided under trademark, under the name of trademark. Okay, you are providing services under any heading, under any name. Okay, then you can provide that name under trademark for the services which you are providing.
Okay.
Patent is an invention. Invention means anything which you invented, which is not earlier in existence.
Yeah, I am trying to create that only, which is not exist earlier. I mean, some new ideas and which. Yeah.
It depends on what you are going to invent. If it is an invention, then it is protected under patent.
Okay, so for that, what I need to prepare for that to take the patent, I need to prepare the document or the ideation and submit it through the government side.
For patent?
Yes.
Yes, sir. There is a process. There is some form which you have to fill up. You will get all detail from our website.
Okay, sir. Okay. And for also I want to invent some gaming industry, which is the again gaming industry is very unique. Huh? So for that also I have to take trademark or patent or copyright.
Patent. If you invented any new game, na?
Yes.
Okay, online game, then you will get patent. You can protect it under patent.
Okay. Okay. Sure. Got it. Thank you, ma'am.
Okay, sir. Any question?
Yes, ma'am.
Hello, ma'am.
I had a question.
Yes.
Suppose a startup that ignores IP may infringe the IP rights of others. So how will I know if it has been copied?
Sir, when we give the patent or trademark design, we publish it. Okay. So in the journal, you got that information from the journal. If you visit our website, that is www.ipindia.in, on that website, the journal is published and all accepted patent, design, trademark are published there. From there, you can find out.
Okay, ma'am.
मैडम लास्ट क्वेश्चन है मेरा फॉर ट्रेडमार्क और पेटेंट रजिस्टर करने के लिए मैं किससे कांटेक्ट करूं, चार्टर्ड अकाउंटेंट फर्म से या कोई लीगल एडवाइजर?
Sir, legal. Those who are working as a trademark agent, trademark agent, patent agent, to them you can contact. But for startup, there are facilitators. Okay, empaneled by DIPPT. And if you contact them, then they will help.
Okay, the contact number you have provided. The same
Sir,
number?
if you go to that website, as I already said that DIPPT website now, there is a list of facilitators in each metro city. Okay, so many advocates are empaneled.
Okay.
So you can contact them and take help.
Okay, ma'am.
Any other questions?
Hello, ma'am. First of all, ma'am, thank you for giving us such an insight about the IPR. I have certain questions regarding the IPR. My first question is, ma'am, how does IPR help in the creation of startups?
IPR, it helps you to create your identity, first thing. Then it protects you from litigation. For example, if you invented a goggle, okay, for example, अगर आपने कोई चश्मा इन्वेंट किया, गॉगल इन्वेंट किया है, जो आपको धूप से बचाता है, जैसे आप गॉगल पहन लेते हो तो आपको धूप में जाओगे तब भी आपको पहनने की जरूरत नहीं पड़ेगी और आप इसका सेल करते हो. This is an invention, novel idea. Okay, but if you fail to register it and I come to know that you invented that such type of product and before commercialization I started using it, okay, then it is a loss for you now. Means it is your invention, your idea, but before your publication I had started using it, then it is a loss for you. Okay, so
yes, ma'am.
if I protect it, then I come to know that this is a protected one. I will not use it, because if I use it, then you can sue me. You can take an action against me, right? And at initial stage, it is good for you to protect your IP. And because government has given you so many facilities to protection at the initial stage. Understood?
Yes, ma'am. Taking this discussion forward, ma'am, if I'm inventing a goggle, okay, and I registered that and I had a patent about it, and in for that government of India, okay, I did a patent in the government of India's websites, but after innovating and after making the products, I delivered in the India market, but some Chinese firm did the reverse engineering on it, and they started producing the same goggle in their country, say in China, and they started their production. They are now dumping their products in the India market. Now this is going to affect my profit as well as revenue. So will I be able to file a case against the Chinese market, the Chinese firm?
Yes, sir. You can take it on the basis of priority. Okay, because you invented it in India, though you got the registration in India, but you are prior than Chinese. Okay, understood?
Yes,
you
ma'am.
are the first inventor. So you will get the benefit of that, though you did not get the registration in China on the basis of priority.
Okay, ma'am.
That's why it is very important to protect your IP. Okay, any other questions?
Yes, ma'am. Hello.
Yes, sir.
Yes, I'm Vivek from Navalwadi Institute. Yes, ma'am. My question is like, if we are in process of patenting our startup, and as we all know, India is fulfilled with a lot of corruption and all, right? So if I'm in process, and because of someone officer is getting corrupted, and my idea is getting copied by them only. So is it any kind of provision in law or any kind of provision in that kind of institutions to save my idea to be
Sir,
from copy?
see, if your invention is through your office, means if you are inventing anything for your office, okay, then it is collectively. No one can claim for that. Okay, अगर आप अपने ऑफिस के लिए कोई रिसर्च कर रहे हैं, ठीक है, तो you are not doing it individually.
Right.
Some people, 2, 3, 4 people are doing research on that. Okay, so in that case, no one can claim monopoly over that. This वो ऐसे नहीं बोल सकते हैं कि ये मेरा है, because already you are collectively doing research on the same thing.
Right.
But if you are doing it individually, आपका खुद का अगर आप कर रहे हो और इनकेस अगर किसी ने वो कॉपी करने की कोशिश करता है, then it is infringement. But in that case also, in patent, before completion of your invention, you can apply. जैसे आपको आइडिया, आपका ऐसा आइडिया है and you started work on that कि कोई आप ऐसे इन्वेंशन कर रहे हो कि जो अभी तक कंप्लीट नहीं हुआ है, आधा है, लेकिन आपको पता है, ठीक है, कि मुझे ऐसा करना है और मैं ऐसा करूंगा, ये कंप्लीट हो जाएगा. तो at the initial stage also you can file, apply for patent.
So before physical existence, I can patent my idea.
Yeah.
Yes. Okay, ma'am. Thank you.
Hello, ma'am.
Hello.
Ma'am, I have one question. Can you throw some light on geographical indications? Like, is it true that individual cannot register geographical indication on his own?
Yes, sir. Geographical indication is registered by association of person or organization.
Okay. Okay, ma'am. Thank you.
Any other questions?
So if you all are done with your questions, then I will request to the Dr. Shilpa Kankunkar ma'am, of Navalwadi, to give a vote of thanks.
Yeah. Good evening, everybody. It's a pleasure to be proposing the vote of thanks. But before I propose, I'm just going to the chat box just to make sure that there are no questions. So I would like to tell all the participants, we give you maybe the next 2-3 minutes. So in case if you have any questions, because we have Manjusha ma'am right from the, we say we need to get the things from the horse's mouth. So we have somebody from a very senior position from the department itself. So it's a privilege to host you, ma'am. So maybe we'll give all the participants maybe 5 minutes more to have any questions they would like to ask you. Otherwise, we go ahead. So any questions, participants? So should we take it that there are no questions? Then we go ahead. All right. So if there are no questions, let me take, yes, somebody's saying something.
Is there any courses, short-term courses available for IPO?
Yes, sir. I show you the 1 minute. This is Rajiv Gandhi National Institute of Intellectual Property Management. They are taking different courses.
Yes.
Introduction, drafting, and all the training they will provide. Okay.
In fact, yes, ma'am. Thank you so much for bringing this up, because I was going to say that in the vote of thanks. We will be doing a series of the sessions by Rajiv Gandhi National Institute of Intellectual Property Management. So, sir, you can be in touch with us. We're planning to line up sessions on this, because the sessions are going to be online, and you can be in touch with us in this group, and we'll take that forward. And thank you, ma'am, for bringing this up once again.
Oh, ma'am, what is the duration, ma'am?
Sorry?
What is the duration?
Duration.
Yes,
Okay.
ma'am.
5 days, 10 days, 1 month. As per the requirement. You can ask them.
Okay, as per the requirement. Okay.
Yeah.
Okay, I will get it in touch with the same phone number.
Okay, sir.
Okay, thank you.
Yes. And you can also get in touch with us. We are also planning to have sessions from the experts directly from Rajiv Gandhi National Institute of Intellectual Property Management. All right. Thank you so much, ma'am. Let me take this opportunity to propose the vote of thanks. It's such an honor for me actually right now, because on the eve of World celebrations for the IPR Day 2022, we have been selected as an online host center. So nevertheless, we are working very hard to ensure that the program goes seamless. But at the same time, this National IP Awareness Mission and the Literacy Week that we planned is going absolutely in line with collaboration from Ministry of Education, Ministry of Innovation, and Ministry of Commerce and Industry. Having said this, Department of Promotion of Industrial and Internal Trade and Office of Controller of General of Patents, Design and Trademark has also helped us in ensuring that we have the seamless support of all the speakers here. So taking my talk ahead, on behalf of Neville Bardia Institute of Management Studies and Research, I, Dr. Shilpa Kankonkar, convener of Institute Innovation Council, Entrepreneurship Development Cell, Neville Bardia Institute of Management Studies and Research, I would like to express thanks, especially to our speaker, Mrs. Manjusha Bopde, ma'am, because she spared time right from, when I spoke to her, she mentioned that I'm available from 10. And that is the kind of sincerity and, the sparing of time that we talk about. We were in touch, and ma'am, you've been so humble and give us, in spite of your busy schedule, you spared your valuable time and you're here talking to us and the entire group. Thank you so much, ma'am, for providing us insights, especially on the pointers which mentioned specifically saying that government interventions are available for the empaneled facilitators. There is also, I would like to mention that there is a startup intellectual protection scheme that is available, which was beautifully covered by ma'am, which was the SIPP scheme. And also, I would like to mention that we have the empaneled facilitator group, which is also available on the website of PPIIT. So anybody who would want to go ahead and register and want to file in, it becomes easier. Also, at this point of time, we are a nodal center for Kapilas. So, as a part of our process, also we help all these startups across, of course, to our students and across for Pune City for registering and trademarking for all their innovations as well as inventions. So, thank you so much, ma'am, for sparing your valuable time and giving us insights on the same. At this point of time, I would like to take an opportunity ahead for thanking all the participants, especially all the faculty members. We have registrations of more than 53 faculty members who had registered for this event. Thank you for being here and being participative to make it such an insightful, interactive session. Also said that I would like to extend our gratitude to the director of our institution, respected Dr. Anand Dada sir, for encouraging us and supporting us in all our endeavors in the field of entrepreneurship development and startup and innovation. At this point of time, a special mention to my colleagues, Professor Rajni Devkate and Professor Vincent Kedari, for having helped us with the entire back-end process, with the seamless interventions that you can actually experience in this entire program. It's all thanks to them, and to make this event actually very successful. And of course, we're not stopping here. We have the second speaker lined up. Mrs. Khushbu Kumari is already here. So we're coming to you, ma'am. But before I do, let me formally thank ma'am for this. And last but not the least, my organizing team, our first year NDSI and MBA members, all the students who are present for the event, as well as our students, Mr. Pradyum Bhosle, Pranjali, Prajakta, and Rinal, for documenting this and doing this a great job of taking the event forward. Because we've been working hard for the last couple of days, and this is what makes an event successful when we have a great team here. Thank you everyone once again, and thank you for just being present and taking this ahead. I would like to tell Pradyum, let's go ahead immediately with the second speaker, Khushbu ma'am. In case if you're ready, we'll take it forward. And if you are having any questions, please feel free to post it on the group. We can take it forward and take it ahead as well. Thank you, everyone.
Thank you so much, ma'am. And I would like to request everybody to please on their cameras so we can take a virtual photograph in the form of screenshot. So if you please stop your sharing your screen, then I can take a screenshot of a gallery. So. Ma'am, will you please stop sharing your screen? So.
Oh, sorry.
Please switch on all the cameras so that we can have a group photograph. Pradyum, is everybody getting covered?
Yes, just okay. Okay, ma'am. Thank you, ma'am. So just wait a minute. Thank you so much. So moving further on the event, there is a small announcement before going to next event. There is a small, if anybody haven't registered yet, the link is forwarded on the WhatsApp group. If you are already registered, then please ignore. So moving to the next event, for today's session, we have second guest lined up with us, Mrs. Khushbu Kumari ma'am. I will give a small introduction for ma'am. Kumari ma'am have completed their graduation in BTech from Dr. B.C. Roy Engineering College, Durgapur. After that, ma'am have completed their MTech from NIT Agartala. Now ma'am are working examiner of patents and designs, Ministry of Commerce and Industry. Now I kindly request ma'am to share their thoughts with us and take the session ahead as it's going very insightful. So I please request my Khushbu Kumari ma'am to take over.
A very good afternoon to all of you. Brief bio about myself. This is Khushbu, and my designation is Examiner of Patents and Design. And in the previous session, you have seen related to startup and how startup is being expedited in India. It's a process filing. But in my presentation, we will be mainly focusing about the filing of patents in India and its procedure and what the forms and what the formalities you have to go through while filing the patents in India. So I would share my screen now.
Ask them if they can see your screen.
Can you see my screen?
Yes, ma'am.
Okay, thank you. Yes, so in the previous presentation, a few of my slides have already been covered. So I will be just briefing out a few of the slides, and in the later slides, which deals with the patent filing procedure, I will deal those files in a very good description. But the initial files, which have already been recited in the previous session, that I would be briefing out. So here my objective is to create an awareness on the intellectual property we have. So starting with the definition of intellectual property. So what is the intellectual property? So intellectual property is a category of property that include intangible creations of the human intellect, So now what is the meaning of intangible creations? So intangible creations are like, it could be ideas, it could be business methods, it could be inventions or musical piece, literary or the artistic works. So these all are the intangible creations. It cannot be touched. It do not have any physical existence, but they do exist. They have a significance, they have an importance. So those properties we will be categorizing under intellectual property. And yes, ma'am, am I audible? Sir?
Yes, ma'am, you are audible. Yes, ma'am. Yes.
Okay, thank you for
your audible.
Yes, absolutely audible.
This, I think these all slides have already been covered, but I will be also dealing with them in a quick section. So what are the intellectual property we have? We have patents, we have designs, trademarks, geographical indications, copyrights, and semiconductor integrated circuits layout design. Now we will see why is the intellectual property important. What are the importance and what are the significance of the intellectual property right? Since now we have seen what are intellectual property. So intellectual properties are those intangible creations of human intellect. And what is the objective of intellectual property right? So one of the important objective of the intellectual property right is to encourage inventions. So how we will be encouraging inventions? So intellectual property right encourage invention by promoting their protection and utilization of the invention, so as to contribute to the growth of industries, which in turn leads to the contribution of development of technological innovations. So this is one of the important objective of intellectual property rights. And there are various other importance and significance of the intellectual property rights, and they are the first one is financial incentives. Yes, financial incentives. This means that intellectual property rights give creators of intellectual property financial incentives. Second one is economic growth. IP rights facilitates the economic growth by giving the statutory expression to the creators. Economic rights by promoting economical and social development through fostering of fair trade. And the last but not the least, intellectual property right circulates the authentic source of information. So many a times the true source, the authentic source of information is very crucial in the today aspects, because most of the so that it is very important to know that what are the technologies that had already been created and what other improvement or what other innovation is required. So in that case, information is very crucial. So intellectual property right makes sure that authentic source of information is circulated among the public domain. This means that IP provides the widest possible availability of new and useful information which has already been published. So, by knowing the already existing technology, there can be a provision that further improvement or the further innovations to the existing technology can occur. Now moving over to the next slide. This shows how a single product can have a different multiple IPs. For example, as soon as you see a brand laptop, in the cover itself, you see a logo, you see an image. For example, here in case of, this is by seeing at the Apple logo itself, we can say that this particular laptop is manufactured by Apple India Limited. As soon as we open the flap, we see a nice LCD screen. That LCD screen is a part of a product, that is invention, and it falls under patents. Now we can see the body of the laptop, that will be covered under design. And every hardware component is accompanied by a user manual, and that user manual will be covered under copyright. And if we see through the laptop, that is, if we see the cross section of the laptop, we can see various semiconductor integrated circuits, various MOSFETs, and various semiconductor chips, that will fall under semiconductor integrated circuit layout designs. Moving over to the next slide, which shows how can we have our own intellectual property rights. So these are the inputs, or the, you can say, investment or the ingredients you have to put in to have your own intellectual property. So the first one is resources. Resources means it includes all the kits, tools, experimental setup that you have to do your experiments. Next is labor. Yes, you have to do a lot of research, you have to do a lot of study to make sure the existing information, to make sure that you have a correct amount of knowledge for the further invention, for the invention that you are going to carry out. And the last but not the least is the brain, that yes, you need a lot of knowledge to put in so that you can create something out of your intellectual, and and you can have a intellectual property right over it. Moving over to the next slide. Yes, this slide is very important because it will tell you why this intellectual property right is important and what are its significance. The first one is protect. Yes, intellectual property right, it gives the inventor protection over his or her creations, and so that it cannot be copied by other people. This means that intellectual property right give the inventor an exclusive right over the creation of their minds, and these rights are usually for the certain period of time. It cannot be for the unlimited period of time. For example, in case of patents, the timeline is 20 years and it cannot be renewed. That is, after 20 years, your invention will fall in the public domain, and anybody in the public can use your invention, and you cannot suit an infringement. You cannot have, so it is limited for 20 years. This means that intellectual property right provide an exclusive right to the inventor for an limited period of time. This means it give the inventor an exclusive right. And the third point is utilize, commercialize, and earn. This particular topic we will see in the upcoming slide in a detail. So yes, in this slide we will see how you can use your intellectual property right for commercial purpose. So the first one is own use. This means this is very obvious way for the owner that that owner has a right to turn them into a source of revenue by using them to create and sell goods and services itself for their own purpose. Second one is license or assign. Assigning means the owner of the intellectual property right can also commercialize them by assigning all or the part of the IP rights to another party, that is the licensee, and allowing the licensee to exploit them. Next is in the assigning, effectively it is the sale of those rights, transferring the ownership to the assignee. Here the entire ownership in the assigning, the entire ownership is transferred to the assignee. For example, say someone is inventing a particular product, but they are not interested in filing patent. The inventor in himself is not interested in filing the patent. So what the inventor will do? Inventor will assign the ownership, the right to the applicant. Applicant could be anyone. It could be a individual person. It could be a organization, startup. So inventor is assigning his or her rights to the applicant, and applicant is filing the patent. So this is the example of assign. Next is the licensing. So licensing means the owner of the IP right can commercialize them by licensing all or the part of the IP right to the another party, that is the licensee. Here we call the another party as the licensee to use in exchange for a fee. In exchange for a fee, usually it is called royalty. So a licensee of the IP rights doesn't transfer ownership in the IP. It only gives the licensee permission to use the IP within the terms of the IP licensing agreement. Just like in case of assign, all the rights of the inventor is being transferred to the applicant, but in case of license, all the rights is not transferred. Like the owner may provide the licensee the permission to use the IP within the terms of the IP licensing agreement. Here, the entire ownership is not being transferred. So this is the difference between license and assign. And in case of license, one more benefit is provided to the applicant, that owner or the applicant may provide the licensee to different manufacturer in different geographical area. Next is the franchise. So franchise is nothing but it is a way of doing business. So franchise is a business relationship between two entities where one party allows the another party to sell its product and intellectual property. A very good example of franchise is several fast food chains like Domino's and McDonald's that operate in India through franchising. And the last one is the merchandising. Merchandising means it refers to the any type of activity that helps boost a product sales to a consumer, specifically in the retail trade. For example, in a store, it refers to the variety of goods available for the sale and the display of this item in such a way that stimulates the customer to buy a product. There are various type of merchandising. One of the important type of merchandise is character merchandise. For example, Disney product. So Disney has the sole right to use the Disney character for the advertisement of their product. If some other organization or some other entity tries to use Disney for their own advertisement, then the Disney can sue them. So this is the very, very good example of merchandising, is the character merchandising of Disney characters. Yes. So we can at the end of the session we can have a query session. So first I will be discussing. So at the end we can have a query session. So this slide show how you can use your intellectual property for commercial use. How you can earn money out of your intellectual properties. So if a common person is inventing something, then it is the matter of pride. It will boost his or her academia. And if a businessman is inventing something, then he can use it for a monetary benefits. He or she can commercialize it. It can enhance the brand value, and he or she can always use their intellectual property to invest, and they can earn out of it. Now we will see the very first type of intellectual property we have, that is patents. Now we will know what are patents, and in the upcoming slides we will see how the patents are being filed in the India, its procedure, what forms are required. So what is patents? We will see in between the lines, and we will try to get the meaning of all the highlighted words. So patent is a grant by sovereign or state. This means that patent is territorial in nature. The patent rights is always bounded by the territory of the country in which it is applied for. So patent is always granted by a country or a state to a person, giving exclusive right to stop others from making, using, exercising, vending, or importing. Exclusive right. What do you mean by exclusive right? Exclusive right means that it gives the inventor an exclusive right so that it protects their right, and nobody else can use their invention for vending, for importing, for exercising. And invention is only for a limited period. This means that a patent is always having a timeline of 20 years. After 20 years, the patent invention will fall in the public domain, and anybody in the public domain is open to use the invention. The inventors or the applicants cannot sue them after that. So the invention is limited for a period, for a limited period, that is 20 years. So all these benefits of the intellectual property you will get, but in the exchange of that you have to do something. What you have to do? You have to file the patent application to the patent office. So you have to clearly file the invention with its complete specification to the patent office, so that anybody having a average skill, anybody having a common general knowledge is able to understand it, is able to reproduce it. So in exchange for disclosing the information to the patent office, you will get all the set of patent intellectual property rights that is associated with the particular intellectual property. That is, you will get exclusive right that will exclude others from using your invention, and owner has a qualified right to use the invention. Yes, now moving over to the next slide. This slide enumerates all the various famous inventions that has been already carried out. For example, Thomas Alva Edison has discovered phonograph. Telephone had been discovered by Alexander Graham Bell. Wright brothers discovered aeroplane. Louis Pasteur discovered famous rabies vaccination, and Alexander Fleming discovered penicillin. Alexander Fleming invented penicillin, and these are very famous inventions that you should know and take inspiration from. These inventions, these are another famous Indian inventions. You can see nano car, a nano car which has been invented by, which is from Tata's for providing an opportunity for middle income families. Next is hepatitis vaccine. It was made very, very much affordable so that a large number of people with low purchasing power could access it. Next is Jaipur foot. Here are another list of famous invention. The third one is very important. You can see the third one is the square dongle. So usually this is used in the Western countries like Canada, where where this type of transaction is used to make payment to the taxi drivers. In India, we can see we always make a transaction at the end of the ride, but immediately the transaction is not reflected in the driver's account. So, but in case of square dongle, immediately as soon as the ride ends, and the person make transaction to the taxi driver, and immediately the transaction is reflected in the taxi driver's account. So this has been very useful in the quick transactions in the Western countries. The last one is the drone. You can drone in the area where it is it is not feasible to physically present and check out the defense system, security system. Their drone has been very useful because this has very much this has reduced the use of various resources and manual physical presence in the area which are very much vulnerable. We can send a drone to inspect a particular area without any presence of without any manual presence or without any resources being utilized. So drone is one of the famous invention we have in the today's sphere. Yes, now this is the important. Now onwards we will be dealing with the patent filing procedure. So this is a slide which tells that how on the very first day of patent filing it could be filed online as well as offline. So on the very first day, these are the forms that I would recommend is Form 1. So yes, first one is the Form 1. Form 1 is titled as application for grant of a patent. So Form 1, it consists of a type of application. So application could be anything. It could be an ordinary application, or it could be a PCT application or conventional application. And in that also it could be a patent of addition, or it could be a divisional application. So in the Form 1 itself, the examiner get to know that what type of application it is, and what are the applicant details, who is the applicant, whether applicant is a individual, or it is a startup, or any organization, or it could be a other entity. So the Form 1 itself tells that what are the applicant details, what are the inventor details, and title of the invention, details of the authorized registered patent agents, and most important thing that Form 1 carries is the declaration by the inventor. As I have already told this, many a times inventor is not interested in filing a patent. So what inventor do? Inventor assign their right to applicant, and applicant file the patent. So this is called proof of right. This is called proof of right or deed of assignment. So in this thing, applicant declare that inventor declare that I am assigning all my rights to the applicant. So Form 1 is, in that aspect also, Form 1 is very important because it contains proof of right, that is a declaration by the inventor. If Form 1 do not contain declaration of the, if Form 1 do not contain the declaration of the inventor, then applicant has to file proof of right separately within 6 months from the date of filing of the application. Otherwise, in the Form 1 itself, the inventor can file a declaration that I am assigning this particular right to the particular applicant. Next is the Form 2. Form 2 contains the details of the invention. The description given in the complete specification shall be in the prescribed format and divided into following section. Form 1 basically contains what details of your invention. It is a full complete description of your invention. It contains what is the field of your invention, what is the background of your invention, and what are the various prior art. Prior art means already those inventions which has been already done before the filing date of your invention, before the priority date of your invention. Those are prior art. So complete in the Form 2 also you will mention what is the background of your invention and what are the prior art, what are the inspiration, what are the invention that you took inspiration from in conducting your invention. It also contains the summary of the invention, and it contains the brief description of the drawings and detailed description of the invention. Next is the Form 3. Form 3 is the Form 3 you furnish the detail that this particular, if you file the similar invention in other countries, that details has to be furnished in Form 3, and there is no fee required for Form 3. In the Form 1, fees has to be paid. In the Form 2, if your invention all the details, if it is within 30 pages and the claims are within 10 claims, then no fees is required. Beyond 30 pages and beyond 10 claims, fees need to be paid. Then come Form 5. Form 5 is very important because it contains the declaration of the inventorship. Suppose you are inventing something, okay, and the invention is not complete, but you want to protect it. So you have filed the invention as not complete specification. Since you have not completed your invention, you have to file provisional specification. Provisional specification means just you have the idea of the process and the product, but you have not completed the invention. So you have filed provisional specification. So within the 12-month time frame, you need to file complete specification. But suppose in the 12-month duration, some more inventor get up to your invention. So what you have to, so you have to inform this to the patent office. So here comes the role of the Form 5. Form 5 means declaration of the inventorship till complete specification has been filed to the patent office. You in the Form 5 you declare all the inventors that were there till the filing of the complete specification to the patent office. And in the Form 5 also there is no fee required. Next is the very crucial thing, is the very important Form 18. Form 18 is a request for examination. So in order to make your patent examined by a examiner, you have to file Form 18. Form 18 could be filed by anyone. It could be filed by applicant or any person interested. So if you are not filing the Form 18 on the day one, you can file the Form 18 within 48 months from the earliest priority date. So if you are not filing Form 18 within 48 days, then we will assume that the applicant has withdrawn the application. So Form 18 is very important. So these are the first, I would suggest that you should file on the day one of the patent filing. Now moving over to the next slide. Yes, this slide deals with the various forms and the fee associated with them. So for the Form 1, if you are a natural person, that is individual, or you are a startup or a small entity, it is 1600. In case of other than natural person or startup, that is any organization or company, it is 8000. And in the previous slide, I have already said if the Form 2, this is within 30 pages and within 30 claims, no fees is required for Form 2. And if the pages are beyond 30 pages and beyond 10 claims, then fees is required. For Form 18, that is the form of examination, applications for examination. For natural person, it is 4000, and for for company, for organization, it is 20,000. So moving over to the next slide. Yes. So you know that you can file patents both online as well as offline. So online there is less fees, and you can always go through this particular site, that ipindiaonline.gov.in, for online filing. You can see this home page. You will see if you go to this IP India services, you will have to log in, and you have to create an account to file patents. Yes, this slide deals with expedited examination. So there is here what we have, a request for expedited examination is an application filed by an applicant requesting the Indian Patent Office to accelerate the examination of the patent application under Rule 24C of the Patent Rule 2003. So here, under this particular examination, there is accelerated examinations. Who can file it? Any startup, small entity, or applicant. If applicant is a female, they can file for the expedited examination. Now we will see in the upcoming slide, we will see in detail what are the patent application processing. Yes, patent application processing. So initially, we see what type of application it is, whether it is ordinary application, or it is a convention, or it is PCT. So in PCT, what happens? You first apply in another country, and within 31 months you have to apply in India, which is 31 months from the date of the earliest priority. You have to file complete specification. If it is a convention application, then within 12 months from the date of earliest priority, you have to file complete specification. And in case of ordinary application, where you have not filed a complete specification, because your invention was incomplete, you had filed provisional specification, then in that case, within 12 months, you have to file complete specification. Within 12 months, you have to file complete specification, and in case of, and it will be immediately, in case of PCT, if it is not immediately published, it will be published not before 18 months. And in case of ordinary application, it is published under section 11A after the expiry of 18 months. So what we do, now your application has already filed in the patent office. Now, being an examiner, what I do, I examine your application. I see whether that particular invention is already been carried out, whether they are inventive or novel or having economic significance, or whether they are having, whether there is any technological advancement or not, and I prepare a first examination report. That report is forwarded to Controller General of Controller of Patents and Design. Now, FER, this means that first examination report is already issued to the applicant. Now, applicant will get a time of 6 months to prepare a reply. If he is not able to, in the reply, he will be replying to all the objections, all the technical objections, all the formal objections that has already been listed in the first examination report. Now, if the applicant is not able to reply within 6 months, he can extend the time by 3 months by filing Form 4. By filing Form 4, he can get total time of 6 plus 3, that is 9 months, in order to file the reply. Here, next thing, suppose the applicant has replied within the stipulated time. So now, he has, in the reply, he has filed the application. He has made a lot of changes in the complete specification as well as the claims. After in the amended stage, we prepare a second examination report, that is SER. Hello, am I audible?
Yes, ma'am, you are audible.
Thank you for your response. So after the second examination report is prepared, now here comes hearing and the disposal. So there the controller will arrange an hearing. It could be offline or online. Now we are arranging a VC for hearing and all. And in the hearing, there could be either grant of the patent or reject of the patent. Now moving over, now in this slide, in the previous, I have said that in the examination process, there are basically two type of examination which is carried out for a patent. One is a technical examination and other is formal examination. In the upcoming slide, we will see what are the technical examinations. So in technical examinations, what an examiner do? So as soon as we get a patent, we go through the complete specification of the invention. That is, we read and understand the invention, and we see, and in the accordance with the drawing, we read the invention, and we see the invention and we search the prior arts. We have a patent search engine. On that patent search engine, we put the particular date, that before this particular date, we want to search all the invention that is related to my invention. This means that I create a list of database that shows that what are the similar inventions or what are the similar kind of process or the product which has already been there before this particular date of filing. And then we decide, based on those searches, we decide whether this particular invention is novel or not. This means that novel means new, whether this particular invention is new or not. And suppose there are two inventions already, invention A and invention B. Now you have filed invention C. Suppose you have taken one features from invention A and suppose 2-3 features from invention B, and you have filed invention C. So it would be novel. It is obvious that it will be new. Okay. In that case, we see whether it is inventive or not. Inventive means as compared to the existing invention, whether your invention is having economic significance or not, whether you have contributed in the price deduction or not, whether there is actual technical advancement or not, how your process is more useful, is more beneficial, how is it reducing the time of the process, or is it economical significance? Has this particular process contributed in the reduction of time, reduction of used resources? So these are the inventive step. So it is very easy to make a new invention, but it is not easy to make an inventive invention. So searching the prior art, and after searching the prior art, we see whether on the basis of prior art, we see whether your invention is inventive or not, whether it is having economical significance or not. So after all this, we prepare a report which is called first examination report. So now moving over to the next slide, which is timeline. Yes. So this slide is very much clearly describing what is the timeline of various forms that you need to file while applying for a patent in the patent office. So suppose, as I have already told you, if your invention is not ready, you just have the drawings, you just have the brief introduction, you just have just a raw data on your invention. So you file a provisional specification. In that case, you can file a complete specification. So to file a complete specification, we give you 12-month time. That within 12 months of the filing of the provisional specification, you file your complete specification. And next is Form 18, that is a request for examination. So within 48 months, you have to file Form 18. If you don't file Form 18 within 48 months, we will assume that applicant has withdrawn the application. So Form 18 is very important. So now we generate FER, and after generation of FER, that is first examination report, the applicant has to file a reply. So that reply has to be within 6 months. And if reply is not prepared within 6 months, then what happens? He can file Form 4. In the Form 4, he can request for extension of time by 3 months. Next is Form 5, which is the declaration of inventorship, which I have already discussed. That has to be filed within 1 month from the filing of the application in India. And these are very important. Form 5 is very important because Form 5 is very important in case you have not filed CS directly. In the ordinary application where provisional specification is filed first, and then after complete specification is filed, in that case, Form 5 is very important. Next, we will move to the other kind of intellectual property we have, that is design. So design means what? As the name suggests, it means a shape or configuration, pattern, ornament, or composition of lines, colors applied to any article, whether in 2 dimension or 3 dimension or in both form. And the manufacturing process could be mechanical, chemical, or the combination of both. And just as I have discussed in patents, the lifetime of patent is 20 years. It is very important to know the deadline, the timeline, that the time of the term of patent is 20 years and it cannot be extended. But in case of design, the term is 10 years and it can be extended to 5 more years, and total 15 years. in case of patents, you cannot renew your patent right after 20 years. Your patent will fall in the public domain, and anybody in the public domain has right to replicate or use your invention. You cannot file an infringement suit after 20 years. But in case of design, it is not that it is only for 15 years. After 15 years or after 10 years, you can renew your design. You can apply for renewal. Now we will see what does an article mean. So article means any article of manufacture and any substance, artificial or partly manufactured and partly natural, and include any part of article capable of being made or sold separately. Design could be a single design, that is individual design, and it can come in set as well. For example, you can see a set. You can see a set of jewelry, or the set of crockery set of furniture. A set means a number of articles of the same general character ordinarily sold together or intended to be sold together. These are called set. This is a filing process of design, which is same that you can file online as well as offline. This means that you can file physically filing as well as electronic filing. In all the jurisdiction, we have 4 jurisdiction: IPO Kolkata, IPO Mumbai, IPO Chennai, or IPO Delhi. For physical filing, DD in favor of controller of design payable at Kolkata. You have to make a DD in favor of controller of design payable at Kolkata. In patents, we saw various type of forms that you have to file in order to apply for a patent. Similarly, in design also you have to file form. You have to file form 1, which will contain applicant details, this nationality, legal status, priority data, prior registration data, and signature and date. Apart from that, in design, you have to file 2 set of representation illustrating various view of article, power of attorney, assignment of a document, and Form 24. Since I am an examiner of patents, I have already discussed the patent filing procedure. This design procedure I would be just discussing in brief. This is the certificate of registration of design you will get after you have registered for your own design. Yes, now we will see. Now moving over to the next point, that is we have showing your IP is protected. So before delivery or sale of any article to be registered, design is applied each article to be marked with registered or RD, and also with registration number, except for textile good and brittle article. Yes, in case of design also, we prepare a first examination report, and reply to the first examination report has to be filed within 6 months from the date of filing of application. Like we saw in patents, that 6 months can be extended up to further 3 months by applying by filing Form 4. In case of design also, after you have in case the applicant reply is not prepared and he seek further time, then he can also apply for Form 4 and he can get a 3-month extension. So in case of patent, we saw the term of patent is 20 years and it cannot be renewed. But in case of design, the term of patent is only 10 years and it can be extended by 5 years, and it can be renewed. In case of patent, after 20 years you cannot renew your patent. But in case of design, its term is 10 years, which is further extended to 5 years, and within 10 years you can also request for the renewal. So request for restoration of lapsed design can also be filed within 1 year from the date of date it was stopped. Yes. So now we have dealt with two type of intellectual property, which is patents and design. Patents we saw in much detail. Now we will see the third kind of intellectual property we have, that is trademark. So this is the one of the sought for intellectual property we have. What is trademark? Trademark is, it could be any symbol, or it could be any logo, it could be any design, it could be or any combination. So trademark is very important to know. Trademark is very important because it distinguishes a particular goods or product from the other. By seeing the trademark sign, by seeing the logo on the device itself, we can see who is the manufacturer of this particular product. It has very important aspect, because it allows a business entity to build public goodwill and brand reputation. Suppose we see a normal good, and suppose we go for buying a shoe, and we see a shoe without any trademark, without any logo, without any image, and second time we see a shoe with a Adidas logo on it. Then by seeing at the logo itself, we can see that this particular product is very good, and it is very durable, and it has a very good brand reputation. So by seeing at the logo, by seeing at the image itself, we can see what is the quality of the good or the services this particular company has to offer. So trademark is very important. It identifies the source, the origin of the goods or services. It assures the customer about the quality of the goods and services. In the next slide, we will see various examples of the trademark. We can see a trademark could be mark, it could be a name, or it could be a collective mark. For example, Naukri.com, or it could be a tagline like "Ye dil mange more." It could be a shape, like the shape of the Coca-Cola bottle, and it could be a sound mark, like in Colombia. As soon as movie start, by seeing at the Columbia, we get to know what is the production house of this particular film. So a trademark could be anything. It could be a sound mark. It could be shape, a tagline, slogan, certification marks, collective marks. Like you can see there, example, you can see a tick mark for Nike, Adidas. For Pepsi, it is Dil Mange More and Naukri.com. These are the various examples of trademarks. Now moving over to the next slide. Yes. Now, how you can say whether this particular trademark is registered or not? We will discuss this. We will discuss what is a good trademark. So, a trademark, it should be not similar to the existing trademark. First of all, this is one of the criteria. And before adopting a new mark, it is advisable to have a search conducted and evaluated. It also avoids unnecessary litigations. For example, you cannot have adjective in the trademark. It is not advisable to have adjective in the trademark like good, superb, wonderful, like this. Now we will see how to indicate whether your trademark is registered or unregistered, or it is pending. So suppose you have TM, if in case of TM is written, that this means that the registration is already pending. It is not registered. And if your trademark is registered, then you can see a R with a circle. So this is how you distinguish between the unregistered and the registered trademark. This slide deals with how do you protect your trademark. So trademark registration is optional, means it is not mandatory, but it will always help you. If you go for registration of trademark, it will always provide you intellectual property rights, and it will always give you recognition. It will boost up your your business, because it will always distinguish your product from the other existing product which are available in the market. So it is always advisable to go for the registration of your trademark. This means that although trademark is not mandatory, it's optional, but registration has always advantages which we have already discussed in the previous slide. So registration available at the national, regional, or the international level. And in case of patent, we saw the term is 20 years. In case of design, we saw the term is 10 years, which is always extended, and it can be extended to 5 years, and it cannot be renewed. It can be renewed after every 10 years in case of design. In case of trademark, initially it is registered for 10 years. And it like design, it can also be further renewed every 10 years. And in case of non-use, non-renewable, or no polishing, trademark rights are lost. So after 10 years, if you are not renewing your rights, your trademark rights will be lost. The existing trademark registration is governed by the Trademark Act 1999 and the Trademark Marks Rules 2017. And for more information, you can always visit ipindia.gov.in. Yes. Now we will see the fourth kind of intellectual property we have, that is copyright. We already dealt with 3 kind of intellectual property, that is patent, design, and trademarks. Now we will see what are copyrights. Again, similar to patent, it is a bundle of rights which are automatic right, and it exclude others from using your copyright work. It prevents the unauthorized copying or reproduction. Yes, this is very important. That you know what are the criteria for work to be copyrighted. The first one is creativity. It should be your intellectual creativity. You should not be copied. You should not copy. The work which is to be copyrighted, it should be new. It should be your own. Second one is original. Yes, it should be original. It should not be copied. And the third one is very important, which is fixation. This means that the copyrighted work should be fixed. For example, you can say like you cannot copyright your voice. Voice is not fixed. It is supposed to modulation. And the thing which are supposed to be not fixed, which can be modulated, cannot be copyright. You have already seen this. You may know that Amitabh Bachchan ji has tried to copyright his voice, but he was denied. This means that this will come under the voice is not fixed. It is subject to modulation. Modulation. How it is modulated? Suppose we are not sick, then we will speak a different. We will speak in a different tone. And suppose we are sick, we have a sore throat, then our voice may get modulated. It cannot be fixed. So a voice cannot be copyrighted. Now moving over to the next slide is the features of the Copyright Act 1957. So provisions related to the Copyright Office and registration to copyright. And second one is provisions to compulsory licensing. Like in case of patents we saw, you can always license your work to other applicant. In case of copyright also, you can always assign your rights. You can always license your rights. Now moving over to the next slide is the provision related to broadcasting right and the performance right. Provisions related to infringement and remedies. Now this slide deals that what are the subject matter that are covered under copyright. So these are literary works, artistic works, dramatic works, musical works. Musical works like you write a lyrics, sounding recording works, cinematographic films. These are the various fields, various works that is covered under copyright. Now moving over to the next slide. Yes, these are the author and the first owner of copyright for the particular type of work. If it is a literary or dramatic work, then who is the owner? Author is the owner. If it is musical work, then music composer is the owner. In case of photograph, the person who is taking the photograph is the owner. In case of cinematographic film or sound recording, producer is the owner, or the producer is the first owner of the copyright. Last one is the literary, dramatic, musical, or the artistic work, which is computer generated. So in that case, the person who causes the work to be created, that is the first owner of the copyright. That is the author. Now moving over to the next slide. Yes, here we see what are the various rights you can avail under copyright. So the first one is economic right and moral right. There is also transferable right and non-transferable right. Transferable right can be transferred or can be assigned to other owners for a sum of money or the royalties depending on the proposed uses of the work. Okay, and in case of non-transferable right, they cannot be transferred. They will always remain with the original author. Okay, so this is the difference between transferable right and the non-transferable right. Now moving over to the next slide. Yes, we will see in the previous slide we saw that copyright, under copyright you get two type of right: economic right and moral right. Economic right we will see in much detail. What are the scope of the economic right? The first one is the reproduction right. This means that the right to reproduce your own work. So it preventing others from making copies of your work. Right to reproduce work in material form. This reproduction right protects your right so that nobody else can copy it. Second one is distribution right. That how you want to distribute your copyright. So anybody cannot make a Xerox of your work and they can use it for business or personal purpose. So this is the distribution right. Next thing is the right to create derivative work. This deals with translation, compilation, and adaptation. Okay, suppose like recently we saw a movie. In that movie Puspa, and the second one is KGF. So we saw that KGF has itself dubbed the movie in Hindi. So this and nobody else, and it didn't give other to translate the movie in Hindi. So it will fall under right to create derivative works. And in Puspa movie we saw it was not dubbed in Hindi, and later on it was dubbed in Hindi. Next is right to communication to public. This means that how you want your work to be communicated in the public. That is relaying of the work by distant or interactive communication means. And the last one is right to public performance, like right to perform the work in the public, like how you want your work to be displayed on the public platform. This will be covered under right to public performance. Yes, now moving over to the next slide, which is scope of economic. Yes. Now how out of two rights, that is economic rights and moral rights, we already saw what are the economic rights we have. Now we will see this moral rights. So under moral rights, it is categorized into two. The first one is right against distortion, and the second one is right against recognition, authorship or paternity. So the first one is right against distortion. This means that your work, you have rights so that nobody can distort your work, like just doing a small modification and reusing your work. This means that the right to object to the work being distorted or used in contexts that are prejudicial to the honor or the honor and reputation to the author. The author can always oppose the distortion of the work in such a way that its cultural or the artistic integrity is adversely affected. The second one is right of recognition, the right to claim to be the author or the work, or to have the authorship recognized. The right to have the author's name mentioned, for instance, when the work is reproduced. This means that whenever the author work is reproduced, then it is our moral obligation to mention the name of the author. So this will come under moral rights. Yes, since while dealing with all previous type of intellectual property, we saw what are the terms and what are the tenures of the intellectual property. In case of copyright also, we will see what are the terms of protection. If it is a literary, dramatic, or the artistic or the musical work, then the term is always life of the author plus 60 years. Okay, suppose the author go to a editorial and he says that you are the author of the particular work. In that case also, the term will be the life of the original author plus 60 years. If it is a cinematographic film and sound recording, then the term is 60 years from the date of publication. In case of broadcast reproduction rights, it is 25 years from the year following the year of broadcast. For performance right, it is 50 years from the year of following the year in which the performance is made. Now we will see what are the application procedure for copyright. This you have to file the form. In such application can be filed in the Copyright Office by person or the post or by e-filing facility. This way I will not discuss in detail. I have already discussed the patent filing procedure. Since my domain is from patent, I am examiner of patents. So this I would be just briefing out. These are the fees for the particular type of copyright that you want to file. If you want to file literary, dramatic, artistic, or musical work, it is 500. In case of cinematographic film, it is 5,000. Like we saw the patent filing procedure. In that we saw how examination is carried out for a particular patent which is filed in the patent office. Similarly, in case of copyright also, there is an examination procedure, like application received at the Copyright Office. Then we do a formality check. Then there is a scrutiny. Then examination report is created. That examination report is sent to applicant. Applicant do some amendment. Then he again file a reply. And after a hearing is done, and in that hearing we decide whether the particular registration could be approved or it could be rejected. Now we will see the second last type of intellectual property we have, that is semiconductor integrated circuit layout design. So we will see what is this. First of all, we will get to know what is the meaning of semiconductor integrated circuit. So semiconductor integrated circuit means a product having transistors and other circuitry elements inseparably formed or inside a semiconductor or insulating material designed to perform an electronic circuitry function. Now we will see what is layout design. Layout design means just the layout of various transistors and their circuitry that includes LED wires, LED wires connecting various elements and expressed in a manner in a semiconductor integrated circuits. So now we see a technology as a technology is in advancement, and there is improvement in the size, there is improvement in the speed, frequency of various hardware we have. So in that in today's scenario, the size of the chip is decreasing exponentially, and the size is decreasing, but the frequency is increasing. It is becoming faster and faster. So semiconductor integrated circuit is being reduced. Initially, it used to be in very big, like huge magnification, but now we are talking in the scale of nanometers. So the size is reducing, but the frequency and the speed is increasing. So this is one of the very important intellectual property we have in the today's scenario. It is very important intellectual property right for the production of product with fast changing technologies such as electronic gadgets, computers, etc. The registration of the layout design is done for a period of 10 years from the date of application filing or the first commercial exploitation. The term is very important. Here in case of semiconductor integrated circuit layout design, the term is it is for the period of 10 years. Now we will see the last kind of intellectual property we have, that is geographical indications. The important thing you need to know regarding this is geographical indications cannot be filed by individual person. It is always filed by association of person or organization. Yes, here are the list of geographical indications here are a few examples of geographical indications. Like you can see Darjeeling tea, Makrana marble, and Nagpur Santra, and Madurai Malli, and Wayanad Jirakshala rice. So geographical indication is what is geographical indication? It is the indication that identifies a product that have a specific geographical origin. Suppose there is a product and there is a geographical indication tag on it, then we will get to know that is this particular product has this particular geographical indication origin. So it possesses the quality and reputation that are due to that origin, and due to that particular geographical indication, that particular product become famous. That yes, this particular product is from that particular state, and it will boost the economical life of that particular area. Next, in this slide, we see more type of geographical indications we have, like this Kanchipuram silk of Tamil Nadu and the Ratlami save of Madhya Pradesh. The more example of geographical indications we have, like Kathputlis of Rajasthan, Bagh prints of Madhya Pradesh, Bengal Pachchitra, and Worli painting, famous Worli painting, yes, and Cherial paintings. Shahi Lichi of Bihar, Kurg orange, Kashmir saffron, Magahi pan, and apple midi mango. Now moving over to the, so we saw this intellectual property is everywhere, in every sphere of life. In even a single product, you can see multiple intellectual property rights are associated with this. Yes, in the next slide we will see here. This is the summarization of various validity or various term life of various intellectual property we have. Like in case of patents, we saw the term is 20 years, and it cannot be renewed after 20 years. patent fall in the public domain, and anybody in the public domain can use it. And then after 20 years, applicant cannot file an infringement suit for the use of particular intellectual property. So the term, in case of patent, the term is 20 years. In case of design, it is 10 years, and it can be further extended to 5 years, and it is renewable. In case of design, it cannot be. In case of design, it can be renewed, but in case of patent, after 20 years, it cannot be renewed. The patent will fall in the public domain. In case of trademark, it is also subject to renewal. After every 10 years, it can be renewed. In case of geographical indications, it is indefinitely subjectable to renewal after 10 years, just like trademark. And in case of copyright, we saw various subject matter of copyright with their corresponding validity. Like we saw published literary, dramatic, artistic, and musical work. For that case, it is a lifetime of the author plus 60 years. Now, who can apply who can apply for the intellectual property right except for GIE? In case of GIE, individual cannot apply for GIE, but in case of other kind of intellectual property we have, anybody can apply. It could be an individual, it could be a startup, it could be an organization. Anybody can apply for intellectual property. Any applicant can apply, or it could be through a legal representative. Person include firm, partnership, small entity, and body corporate. And last line is very important, that all IP rights are territorial in nature. This means that the right is always bounded by the boundary of the country in which it is applied. For example, you have applied in India for a particular product to be patented. So your right is always limited within the territorial boundary of the India. You cannot ask for right in other country. In order to get your rights in other country, you have to separately apply in that particular country. So this is the meaning of the term territorial. This means that all IP rights are always limited within the boundary of the country in which you have applied for it. Now moving over to the next slide. These are the points to remember, that before publishing your intellectual work, you need to protect that. In case of journal, suppose you have already published the journal, then within 12 months you can file patents. If you are filing after 12 months, then that particular journal will act as a prior art to your invention, and there will be no novelty then. So in case of journal also, if you want to file patent, then within 12 months you have to apply for the patent. Next important point that we have discussed in very much detail is rights are always territorial. That is, it is limited to the boundary of the country in which it is applied for, and registration is done by the sovereign authority. That is, you will be getting rights by the government of India. Next is limited. Rights are limited period of time. Yes, for in case of patent, it is limited to 20 years, and there is no automatic relief. You have to if you find that your intellectual property is being copied or being used without your permission, you can always file an infringement suit, and renewal fee has to be paid on some IPRs. Last point is appointment of patent agent is not compulsory. This means that you may not take the help of patent agent for filing of patent. Applicant yourself, if you are the applicant, you yourself can file the application, and if you may need patent agent, you may not need patent agent for filing the application. Next, we will see career opportunities. What are the career opportunities in this field? So you can see, this is a very reputed government job, and it provides various designations like examiner of patents and designs, and examiner of trademark and geographical indications, and examiner of copyright. So there is an exam which is a CG PDTM, that is Controller General of Patent Designs and Trademarks. You have to go through that exam. It consists of 3 stages. The first one is prelims, and the second stage is a written exam followed by document verification. You have to go through all the 3 stages to qualify for this particular job. The other designation being patent agent, whose exam is on this next week. So the next is trademark agent, patent agent, ZRF, SRF in the patent facilitation centers, patent litigations, and other opportunities and there are various other opportunities in the private sector. Now, as discussed in the previous session, the ma'am has discussed, you can always contact to Rajiv Gandhi National Institute of Intellectual Property Management, RGN and IPM. And here we conduct various courses and various courses on various topics, where you can have a very detailed knowledge of any particular intellectual property that you are seeking knowledge for. So here you can always contact, and you can always go through this IP India services for the upcoming trainings. Now, after since we have completed the session, now we will have an interesting quiz session. So you can always reply in the chat box, and you may unmute yourself and answer also, but it would be preferred if everybody reply in the chat box. So here is the quiz. Now moving over to the first question. So here you can see there is a grid box, and you are supposed to find famous trademarks. Can you please identify various trademarks that are hidden in this grid box? If I am audible, please reply.
Yes, ma'am, you are audible.
So everybody, please find important trademark that are hidden in this grid box.
Amul.
Yes, Babul is correct. Pepsi is correct. Yes, ma'am, Amul is correct.
Dettol.
Yes, you can see Dettol as well. What else?
Pepsi.
Cadbury. Yes, sir, you are right.
Bata.
Babul.
Yes, Babul. So since we have a constriction of time, we would move to the next slide, which is dealing with the answers. So everybody has pointed out, like, all the famous trademark which was listed in the previous grid has been pointed out, like Pepsi and Cadbury and Babul. Now moving over to the next interesting question we have, like these are the here in the particular figure you find various intellectual property. So you have to tell what intellectual property you can find here. In the first, this is a painting, so this will fall under
Artistic.
Artistic, yes, copyright. Next is the next one, next sculpture. Under which intellectual property it will fall?
Is it geographical?
It is a sculpture, and it is a design as well. So it may fall under design as well as copyright. Okay, moving over to the third picture, under which IP you can find here?
Design and logo.
Yes, logo, that is trademark. Yes, correct. So you can see design also, and you can design also as well as trademark. Fourth one, under which IP it will fall?
Brand name.
Trademark, right?
Brand name.
Trademark.
Yes, yes, sir, you're right. Last one under which IP it will be falling for? You can see the design, or you can see the bottle. You can see that the name, trademark as well as
trademark.
Design as well as design. You can that particular shape of the bottle, that particular configuration, that can fall for design as well as trademark. Now moving over to the next question. Yes. Which type of IP protect the painting painted by artist?
Copyright.
Correct. Absolutely correct. What protects the intellectual property created by fashion designers?
Design.
Designs.
Correct. Next is what protect the advanced disc brake? It is a invention. So what protect the
Patent.
advanced disc brake by inventors? So wherever there is invention, it will be always dealing with patents. Which of these is a geographical indication?
Nagpur orange.
What does a trademark protect?
Logos, names, and brands.
Logos, names, brand.
How long can a patent last?
20 years.
20 years.
I heard
20
60
years.
years somewhere. Oh, it's 20 years. Whether it can be renewed or not?
Yes.
Yes.
Renewed.
Oh, no. Patent is, the term of patent is 20
Patent
years and
but
it cannot be renewed.
designs can be extended to 5 years.
No. In case of design, it can be extended.
Yeah, in case of design,
In
yes.
case of patent, it is only
Cannot
for
be-
20 years, and after 20 years, you cannot renew it. After 20 years, whatever you have invented, it will fall in the public domain. And in the public domain, and you cannot have right to prevent other from using your invention. So patent, can patent be renewed or not? No, it cannot be renewed.
No, cannot be renewed.
Just like design, trademark, and various other kind of intellectual property that I have discussed, they can be renewed, but patent cannot be renewed. Now moving over to the next question. Yes, this is very interesting question. If you write an original story, what type of intellectual property give you the right to decide who can make and sell copies of your work?
Copyright.
Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can we use to show that
Design.
clothes are made by his company?
Design.
Trademark, right?
No design.
No. Trademark is the medium by which you can monopoly over your own product. If you cannot, after registering for a trademark, if you are able to distinguish your product, then it will be distinguished from the other. He can have a sole monopoly over his own clothes or design.
Because the cricketer is involved. That is why. Otherwise, the plain cloth.
Patent is not involved because patent is always relating to invention. If there is no invention, it cannot fall under patents. So here it is telling which type of intellectual property can he use to show the clothes that are made by his company. He has to create a logo. He has to create an image or logo that will distinguish other product which are currently in the market from his product. So the answer will be trademarks, right? Next question we have: if a company develops a new technology, that improves its main product, this means that there is an improvement to the existing invention. So what type of intellectual property can they use to stop others from copying their invention?
Technology means patent.
Technology means patent. This means patent. Either you can apply for patent something which is very new technology, suppose which is actually new, And also you can also apply for patent the technology which is an advancement to the existing. Suppose the brake system has already been, suppose an example I am giving, brake system has already been invented. Suppose some inventor develops disc brake, which is an advancement to the existing brake technology. So he can apply for the patent. So patent could be for anything, any new product or process which is new or which is having a technology, which is having advancement to the existing technology. So here, yes.
But if a mechanical product is been advanced by the new technology, can it be also registered under design also?
No, sir. In design, you can seek protection for a particular shape, configuration, and whatever invention you do or whatever improvement in the existing invention you do, that will be falling under patents only.
Yeah, but if I little bit modified the shape and design of this one.
Yes. If you modify the shape and design, then you can apply for design intellectual property.
Simultaneously for the new technology patents and also for the design.
You have already decided the word technology. So for new technology or new invention, it will be only patents always.
Yeah, but simultaneously on the modified design also.
Yes, just like in the previous illustration, I in the patent when I was dealing with, I saw you have seen one in one file in which you had seen a single product can have multiple IPs, like the laptop design. Its design was or its shape was will be falling under design, and the screen, the LED screen you saw, that is technology. So it will be falling under patents. So that single product, it can single product can be under both category, can have multiple intellectual property. It can have patents as well as design. So in your case, since we have said you are also modifying the design of the technology, the shape and configuration, so it will fall under design. So, and if you are adding to the technology, if you are doing some if you are making inventive changes to it, or that is you are modifying it economically, it will be falling under patents.
Okay, ma'am.
Okay, sir. So moving over, now I think this is the last question of our query. Now it is thank you slide. If you have any query, you can ask. And since we have there is one back-to-back more presentation in the upcoming after this, so I would recommend please ask your query in a quick.
Ma'am, I have one question.
Yes.
If my product or idea has been patented under Indian patent law, but
what your product or idea?
Even a product or idea.
No, sir. Idea cannot be patented. It has to be always product or process.
Okay. Suppose that product has been patented under Indian laws, and suppose simultaneously somebody copied and apply for a patent overseas. Do I have a protection right to protect him?
No, sir. Since I have already recited in my slide that patent right is always territorial in nature. It is always bounded within the country in which you have applied for the patent right. You have applied for India already, so you have patent right always within the territorial boundary of the India. If
I understood, but
overseas you cannot seek protection for. If you want to seek protection, then in that particular country you have to apply for patents. In order to file an infringement suit against that person who have copied your invention, you have to file your application before that person copies, so that you have a priority date. And after priority date, nobody can copy you in that particular territory, in that particular country.
So in that case, I need to keep applying every country as an individual basis.
Yes. There's one route which is called PCT route. PCT means patent cooperation treaty in which similar application you can file in all the country in which you want to seek your protection, and it's the same thing you have to inform to the patent office in the form 3. Form 3 details, you have to furnish all the details that in which country you have applied for that particular patent, and when you have applied, and what are the status of that patent, like it is in the application stage or it is in the publication stage. So yes, so you have to furnish all the details in the form 3 to Indian Patent Office that this particular invention I have applied in this particular country, and here I am seeking protection.
So is there a single window to apply globally?
Single window, no sir, you have to follow 2 routes. We have actually 2 routes, conventional route or the PCT route. So you have to follow PCT route.
Okay.
Ma'am, good afternoon.
Good afternoon, sir.
Thank you for your nice presentation. We could get lots of new things today to learn. Ma'am, one question regarding this Nagpur University for Patent. What exactly kind of course? And if we go for that, how it will give us advantage in our career?
Yes, sir. This information you can get from IP India services. Here, once you surf through this site, sir, you will be getting a various kind of various training which is about to held in the Nagpur Institute, and that particular details you can get it from there, from the IP India services.
Thanks. Thank you, ma'am.
Thank you, sir.
Hello, ma'am.
Hello.
Hello.
Hello, sir.
Hello, ma'am.
Hello, sir. Please ask a query.
Ma'am. How can I know whether my invention is patentable or not?
Yes, very good question. So under Section 3 of Indian Patent Act 1970, you get a list of points which tells what kind of things are not patentable. Like number 1, like you cannot patent a computer program. You cannot patent under Section 3K. You cannot patent for computer program per se or business methods. Which are not patentable.
Thank you, ma'am.
Thank you, sir.
Yes, ma'am. I have one small question.
Yes.
If someone has patented their product and I want to sell the same product, so is there any permission do I have to ask for?
Yes. Yeah, you can. If that person license you, that person make you as licensee, then only you can have. Then only you have the permission to use the other inventor product for your marketing purpose. So you have to ask their permission. So
Okay,
they will
like government laws.
You have to, if they make you assignee, or if they hand over some license to you, then only you can use their product for business purpose.
Okay, is there any duration for that?
Yes, in the license only they will be providing all the terms and conditions that for this particular period of time, I am assigning my rights to you. I am licensing my rights to you for this particular period of time. In the license certificate, it will be mentioned.
Okay, thank you.
Seeing at the time constrictions, I would like to know if there are any more queries.
I think, ma'am, we wouldn't have any more queries because that's what I see from the chat box as well. I think you've been a great speaker with your lucid language and articulately putting the thoughts across. Thank you so much. I think, Pradyum, we can ask you to take it forward. As a part of the procedure, ma'am, we have a small video that needs to be played, and we want you to be there as well for that next maybe just 7 minutes. It's part of the procedure that the AICTI has sent it further. Will that be okay with you? All right. Thank you. Yes, Pradyum, please take it over.
Thank you so much, ma'am. Being aware is quality of sound mind. And as Indians, we give our extra thoughts to when it comes to awareness. So thank you for such a wearing and amazing session. Now I request Dr. Shilpa Kankonkar, ma'am, convener of EDSISL, to give a vote of thanks on the behalf of EDSISL.
Okay. Yeah, good afternoon, one and all the faculty members present here, and of course, Khushbu Kumari, ma'am, your presence has been so beautifully put up in terms of the knowledge that you added for the entire session. Your lucid language, followed with the way very beautifully explaining the very simple examples with respect to the process, with respect to the procedures. I think we should really appreciate you for that. And having said this, also thank you for gracing our occasion and removing out time to be present for this event, because this event has been in collaboration with Ministry of Innovation, Education, AICTI, and the Department of Intellectual Property Rights India organization. So thank you so much. In fact, taking this a little forward at this stage, I would like to also, express my gratitude to our respected director, sir, Dr. Anand Kumar Dadas, for having, encouraging us and supporting us at every endeavor that we want to take ahead with respect to our innovation activities that we do at our institute. And also to my fellow colleagues, Professor Vincent Kedari and Professor Rajni, having, helped this entire seamless operations of going through live as well as being there in the Zoom link. And also to the entire organizing team, my students being there here, with all of them put together, I think we make a great team, and also my other students who will be doing other events in due course of time. So thank you so much, one and all, and also all the faculty members who graced the occasion here. There's a small video before I, bid adieu to the program. There's a small video as a part of the procedure that we would like to play for the Kapila program. It is given by Mr. Mohit Gambhir, who heads the entire Kapila scheme for the entire scheme of innovation that we want to propose ahead, as we have been selected as an online host for the scheme itself. So that is the reason we thought of taking this event ahead and having prolific speakers like you. So, especially bringing it at the grassroots level of what can really be making a difference. I think Khushbu, you've had a great difference there. Thank you so much. We've got some encouraging comments coming through in the chat box as well. So thank you so much. If you have anything to say, please feel free to tell us. And Pradyum, I would like you to put the link in case if you have it, otherwise we do it here from here.
Yes, thank you so
Do
much.
You have the link?
Yeah, yes, ma'am. The link is already in the chat box. So please fill up the feedback form in the chat box or WhatsApp group. So EDSISL can arrange more and more of like these sessions for all of you.
Also, yeah, and there's another link that we would be playing. So please, we are the host right now. Okay, so who's the host right now, ma'am? If you could make us the host right now, we would like to play the link.
So should I stop my share?
Yes, yes, ma'am. Before that, ma'am, can we take a virtual photograph in the form of screenshot?
You would request everybody to start their cameras for a virtual photograph.
Please will be.
Yeah.
Please on your cameras for 1 minute, so just we can take a screenshot. Done. So done. Thank you, everybody. Thank you.
Yes, Pradyum, you can go ahead with the link of Mohit Gambhir, sir.
Who is the host now?
Get the host. 1 second. Yeah, ma'am, Khushbu ma'am, could you stop your screen share so that we could make okay,
Yes, I've already stopped my
yeah, ma'am, you will have to
Ma'am, will you please make me host so I can go ahead with the video?
Just a minute.
Yeah, Pradyum, you can go ahead.
So I'm waiting for ma'am to make me.
Just a minute. So how should I do that?
There, on your profile there is a option slide, like 3 dots on the upper right corner. So you just click
On
there.
the upper right corner, you'll get 3 dots there, Khushbu ma'am.
On my profile.
Okay. So stop live stream.
You can just click on it and
click on make
and
host.
It will say.
Just a minute. Actually, I'm not aware. Can you please help me out for this? How should I change the host?
See, you can go on Pradyum Bhosle. On the right side, there are 3 dots there. So once you go to the 3 dots, it would specifically mention make Pradyum host. Got it?
Just a second. Can you do this at your end?
Because since we have made you the host, we cannot do that, ma'am.
Okay, more. More. Make host. Okay, I have done.
Yes, ma'am.
You want to change the host of Rhythm host? Yes. Okay, is it?
Okay, thank you, ma'am. Thank you so much, ma'am. Now I'm host.
Done. Thank you so much.
Thank you so much, ma'am.
Thank you.
So we are going to look at the video made by the Mohit Gambhir, the Director of Ministry of India. So he has given a message for all the future entrepreneurs and innovative minds who have joined here. So now I request Pranjali to please play the video. Pranjali?
Yes.
My warm greetings to one and all present here, all the dignitaries, all the learned people who have gathered here on the beautiful occasion of World IP Day and the celebrations which are being done with Indian Patent Office in collaboration with AICTE MIC to disseminate the information among all the stakeholders across the country about the importance of intellectual property, Bauddhik Sampada. As I always say, no country can ever reach to become a robust economy until and unless that country moves forward and works genuinely and seriously in protecting the IP. And not only protecting the IP, once it is done through the best possible means, then try to commercialize, try to generate revenues. So IP has to be a valuable asset. And in line of that, through Innovation Cell at AICTE, what we are trying to do, since past 1 year, we have started a program named Kapila. Under this program, that is named after our ex-president, Dr. APJ Abdul Kalam, Kalam Program for IP Literacy and Awareness. We started under this program a few kind of small events to engage our faculty members, to engage our students across the country in various colleges through our establishments, IICs, which we have done, Institutions Innovation Councils. And I'd like to thank everyone who has participated so far and who are trying to gain the maximum out of it. Under this program, we are trying to we are trying to imbibe the culture of innovation, IP generation, then filing that IP, securing the IP rights, and then taking that particular course. Friends, in IP domain, and I'm sure you all are aware of, in many lectures of ours we have said, and the data is presented, that China is way far leading in filing international applications. They are filing in tune of 15 lakhs, and then US is filing in tune of 7 lakhs, and India we see around 60,000 applications per annum. We genuinely need to increase this filing rate. As of now, I believe. It's just like I always compare this phase with our own lives. As a human life, what we do. So after taking birth, it is a time of we spend few time in prime, then we start scrolling, then we start standing, then we start taking small steps. Generally it is being termed as baby steps. Then we learn to walk in a steady manner, and then we start running, sprinting, running, and take the lead. So these are all a kind of phases. In a very similar manner, if we take it in IP and in protection of IP, we are at the stage of prime as of now, I say. At the prime stage where like we human lives are being nurtured in a similar manner. I believe the IP knowledge and the filing of IP, it needs nurturing. It may take another few years where we all will understand what is to be done and in what manner. It's again similar, just like learning by the experience. Many people say that what will happen when we are going to increase the number of filing. So I very candidly say, let's increase the number of filing today. Down the line tomorrow, we'll understand what to file. Down the line next year, we will understand what not to file. Down the line another year, we will understand what has to be there in that application. Down the line next year, we will understand what is the kind of drafting or the claims or the value add features we need to do during our ideation process that has to be filed in IPR. So it is again a gradual process. Considering that, coming back to our Kapila program, we proposed and we received the approval from our competent authorities to provide the matching grant to the institutions. Like if an institution is filing 20 applications, we would be providing the grant for 10 applications in terms of filing fee and the examination fee. You all will be really delighted to know, and I'm sure again this information is very well disseminated. Earlier, what used to happen in our Indian context, I am talking about, IP is being filed many times because of the fee constraints. Individual inventors, they used to file on their own name, and themselves as an applicant, citing their address as an institutions. But friends, to all the faculty members, to all the students who are listening to me, please understand, we are working for an organization, and if an IP is being generated by utilizing the infra of that organization, applicant should be there as an organization, and to the organizations there must be some clear-cut policy that what inventors would be gaining out of it. There are a lot of policies that has been even proposed by our own innovation cell under National Innovation and Startup Policy. All of you can go there, all of you can look into what kind of percentages and all other granularities are there which can be considered while drafting our own IP policy of your own institution and how things are to be taken forward. Major step has happened last year, August 17, 2021, when Honorable Minister Shri Piyush Goyal ji announced a landmark thing in our IP regimen by reducing the fee for academic institutions to 80%. So I believe then there is no stopper or no blockage for our institutions. And earlier, the hefty fee they were paying, it is now at par with individuals. We need to join hands together. We need to understand the critical nature of this whole IP regimen and come forward in protecting our ideas. There are many situations where we may think, yes, this is an IP and it is to be deployed for masses at large. Certainly, we should do that. Certainly, we should move ahead in that direction. But after protecting our IPRs. As an applicant, as an inventor, you guys have to decide what to do thereafter. But take a step forward. Taking those steps and these steps after steps will only make us leap forward. My dear colleagues, peers, and everybody, all the student and the academic fraternity out there, please work together. I'm sure this whole week, the way it is being celebrated, it is being formed to provide you the desired information. Lot and lot of IP would be generated and would be filed. Thank you so much and all the very best. Once again, thanks to the organizers and the management of the institutions wherever you are listening me, and all the departments who join hands to take it forward. My colleagues, Professor Unnat Panditji, Dr. Abhay Jere, our higher authorities, Professor Anil Sasabudhe, Professor MP Punia, Professor Rajiv. Thanks to everyone who made this possible, Dr. Ellen, Dr. Sonal, who are running the Kapila program. I'm sure together we will be able to achieve today what looks impossible. We always desire for. All the very best. Thank you so much.
Yes, over to you, Pradyum.
Thank you so much, Khushbu ma'am, to be there. And let me also tell you, ma'am, that we have been selected as the nodal center for Kapila scheme. So maybe fingers crossed, we'll have some applications coming from our side to you. So thank you so much for being there and enlightening us on the entire procedural requirements. Thank you. before we close down, Pradyum, the feedback link has been put, the registration link for the certificate generation. Yeah, the registration link of the certificate for the certificates have been put in the WhatsApp group. So keep looking at it, and in case you'll have filled it, it's okay. Yeah, thank you so much, ma'am. I think we can call it for the day. If anybody has
Thanks so much, ma'am.
to ask to ma'am, she's still there. So otherwise, thank you, ma'am.
Thank you, everybody.
I think we can call it for the day.
Okay. Okay. Thank you all. Thank you, ma'am. Thank you, everybody, for being in this. Thank you.
Yes, ma'am. You're saying something?
Yes, ma'am.
All right.
Yes. I thank everybody who joined here today for the session on behalf of SSL, and I thank all the guests and who have managed this beautiful course. And I request you all to please fill the pre-work form which is posted in box and also on the WhatsApp group. And thank you, everybody.
Okay. And in case if any participants have anything to say, please feel comfortable. Anybody would want to say anything? The faculty members who are attending this program. All right, then we call it for the day. Thank you so much for being there. Thank you.